Welcome to Divorces Schmidt, a family law series. In this episode, I'll discuss how forum disputes are determined in family law and how this differs from the usual Australian approach to forum disputes. A forum dispute arises when two different courts are asked to determine the same subject matter. In the family law context, this generally means a forum dispute between the Federal Circuit and Family Court of Australia, either Division 1 or Division 2, and a court in another country. Most Australian lawyers will be at least vaguely aware that the usual test to be applied to a forum dispute is whether the Australian court is a clearly inappropriate forum. We were all taught a bit about that in law school, and we probably all have vague memories of authorities like Voth and Manildra flour mills. However, like many other legal concepts, family law does things a bit differently. In 1994, the High Court in ZP and PS determined that the rule in Voth applied to all matrimonial proceedings except parenting matters. Since then, the full court of the Family Court has repeatedly confirmed the approach to be taken in relation to forum disputes in family law. The correct test to be applied depends upon whether the forum dispute involves parenting issues. If parenting is in play, then it depends on whether the dispute is solely about parenting or is about parenting amongst other matters. In essence, if the forum dispute is solely about parenting, then the clearly inappropriate forum concept does not apply. In those cases, it's the usual question of the child's best interests which will determine whether the parenting dispute is to be decided in Australia or in the other jurisdiction. If the forum dispute involves issues other than parenting, then the clearly inappropriate forum test applies. Interestingly, where more than parenting is involved, it's open to the court to split the forum question, such that the forum dispute about parenting is determined separately on the basis of the child's best interests, and the forum dispute about the balance of the issues is determined according to the clearly inappropriate forum test. Really simple, huh? If the forum dispute is to be determined on the basis of the child's best interests, then those interests are assessed by the court in the usual way, and I won't go into that in any further detail here. If the clearly inappropriate forum test applies, there is guidance to be found in several full court decisions as to what matters ought to be considered, in addition to the non-exhaustive list of considerations set out by the High Court in Voth. The matters to be addressed and considered with respect to each of the competing jurisdictions include whether each competing court has jurisdiction to deal with the dispute. Now that's usually a given by the time the Federal Circuit and Family Court is asked to determine a forum dispute. Then there is the convenience, expense and location of witnesses. For example, if most of the relevant witnesses are in the forum jurisdiction, that would weigh in favour of Australia being a clearly inappropriate forum. Next is each party's ability to participate in the proceedings, which can include things like language and whether a person is required to personally attend the relevant court. Another factor is the connection to jurisdictions and issues upon which relief may depend. Then there is whether each jurisdiction will recognise the other's orders and decrees. And this is an important factor when parenting is involved but the clearly inappropriate forum test applies. And I'll have a bit more to say about that shortly. Then there is which forum may provide more effectively for a complete resolution of the party's controversy. There's also the question of the order in which the competing proceedings were instituted and costs which have been incurred in each jurisdiction. There is the governing law for the dispute, the place of residence of the parties, the availability of each forum, which includes things like how long parties have to wait for a final hearing in each of the jurisdictions, and any legitimate juridical advantage to litigation in either jurisdiction. I want to turn back now to the question of whether each jurisdiction will recognise the other's orders and decrees. The full court in the 2017 decision of Kent held on this point that if the orders of the foreign court will not be recognised in Australia, that will ordinarily dispose of any suggestion that the local proceedings should not continue. If the matter involves parenting issues, this can be determinative of the forum dispute, so it's essential to research whether an order of the competing foreign jurisdiction will be recognised in Australia. To do this, we need to look at Section 70G of the Family Law Act, which provides for the registration of overseas child orders. The term overseas child order is defined in Section 4, subsection 1 of the Family Law Act, and it means an order made by a court of a prescribed overseas jurisdiction that, and then it goes on. So what does that mean? Well, we've got to turn to the Family Law Regulations 1984, and particularly Regulation 14. Subregulation A of Regulation 14 points us to Schedule 1 capital A of the regulations, and says that each country or part of a country set out in column 2 of that schedule is a prescribed overseas jurisdiction. In essence, if the country or part of the country in which the competing court sits is not there, then the overseas child order will not be recognised in Australia. For financial matters, it's a bit less clear. There is no equivalent provision to Section 70G in relation to overseas property orders. There is, however, authority in relation to the enforcement of overseas property orders. A recent example is the 2022 decision of the Federal Circuit and Family Court of Australia, Division 1, sitting in the appellate jurisdiction, in the case of Yardoo and Orchard, where the full court held that the enforcement of an overseas property order fell within the meaning of a matrimonial cause for the purposes of Section 114, subsection 3 of the Family Law Act. In that case, the foreign court had made orders about property in Australia. Now, in my experience, it can be necessary for parties to obtain orders in both jurisdictions in relation to property. For example, a few years ago, I was involved in a matter where the parties had property in Australia and mainland China. The parties had never lived in Australia prior to separation. After separation, the husband had removed something like $750,000 in matrimonial funds from China to buy real property in Australia with his new partner. A court in China had already made orders about the property owned by the parties there, but declined to make orders about the Australian property. Subsequently to that, my client, the wife, who had never lived in Australia, applied for property adjustment orders here. My client had used expert evidence from her Chinese lawyer as to the inability of the Chinese court to deal with the Australian property. The court in Australia determined that it was appropriate for it to deal with the adjustment of the Australian property. Now, these are issues which in my view need to be investigated and assessed in each case and in relation to each jurisdiction. In my view, the question of the recognition by each of the competing jurisdictions of the other's decrees is not likely to be determinative in property-only proceedings. I'm Johannes Schmidt. Thank you for listening. I hope that this discussion has been of some value to you. If you'd like to be notified as I release further episodes of Divorce with Schmidt, please follow me on your preferred social media platform, subscribe on YouTube, or subscribe on your favourite podcast